encryption, anonymation tools, and virtual private network make tracking offender difficult. By the time investigative agencies initiate action, critical evidence may already be lost. Another major challenge is capacity and training. Investigators require specialized skills in digital forensic, data recovery, cyber intelligence. Coordination between the law enforcement agencies, service providers, and international authorities is essential but often complex. From the perspective of prosecution, the presentation of digital evidence in court poses its own difficulties. Ensuring admissibility, establishing authenticity, and maintaining continuity of evidence are crucial to securing conviction. The digital forensics has become central to modern criminal justice. Process of acquisition, preservation, and analysis of digital evidence must follow scientific protocols. Chain of custody may be strictly maintained. Every stage, from collection to storage to presentation, must be documented. Even minor procedural lapses may affect the credibility of evidence. Courts increasingly rely upon CCTV footage, call data records, metadata, emails, WhatsApp messages, social media communication, and digital photographs. However, understanding the scope and limitation of forensic report is equally important. Expert opinion assists the court, but does not replace the judicial scrutiny. And probably that was emphasized by Brother Justice Amanullah when he made his concluding remarks. The concept of integrity of evidence must remain at the heart of all investigations. This ensures fairness to both victim and the accused and strengthens the public confidence in justice delivery system. India has developed a comprehensive legal framework to deal with cyber offenses, including provisions under the Information Technology Act and the new criminal laws. Judicial interpretations continue to evolve, balancing technological advancement with constitutional safeguards. Procedural safeguards relating to privacy, due process, and protection against misuse of surveillance power must always be respected. As custodian of constitutional values, courts must ensure that technology strengthens liberty and security rather than undermines them. The admissibility and appreciation of electronic evidence requires clarity, consistency, and continuous legal education. Lawyers, prosecutors, and judges must remain updated with the changing legal landscape. Awareness and prevention are important as investigation and punishment. Legal literacy plays a crucial role in empowering citizens to recognize and avoid cyber threats. Legal aid providers, lawyers, and law students can become agents of digital awareness. Through outreach programs, community engagements, and innovative tools such as audiovisual initiative as Drishyam Vidhi, we can bridge the gap between law and society. Training programs for investigators, prosecutors, and judicial officers must be continuous and practical. Collaboration between forensic institutes, universities, and legal service authorities will help to create skilled ecosystem. Cyber security cannot be ensured by a single institution. It requires a coordinated and collaborative approach involving the judiciary, police, forensic expert, technology professionals, academia, and civil society. Standard operating procedure, technological upgrades, data sharing mechanism, and international cooperation must be strengthened. Equally, ethical and responsible use of technology must guide all stakeholders. The focus must shift from reactive response to proactive prevention, resilience and public trust. In conclusion, cybercrime represents one of the greatest challenges of our time, yet it also presents an opportunity to modernize our institutions, strengthen our laws, and build a judicial system that is both technologically advanced and constitutionally grounded. I'm confident that the distinguished panel today will provide valuable insights and practical solutions. I look forward to learning from their experiences and wisdom. With these opening remarks, I once again thank the organizers and all participants. I also wish this session meaningful deliberation and productive outcome. And then I conclude with a beautiful couplet, the effort of this conference that can be summarized in the words of the great Dushyant Kumar, हंगामा खड़ा करना मेरा मकसद नहीं है, मेरी कोशिश है कि सूरत बदलनी चाहिए. Thank you all.
Thank you, Lordship. Thank you very much for this introductory speech and giving us the way forward. Now, may I please request Honorable Mr. Justice and Kotiswar Singh, Judge Supreme Court of India, who is also a co-chair. Sir shall speak on topic electronic evidence under new criminal laws. Sir.
Good afternoon, my esteemed brother Justice Varale ji and brother Ashok ji, Judge of Rajasthan High Court, Vikas ji, IPS Deputy Inspector General of Police, Cybercrime, Rajasthan, and Learned Counsel Dr. Rishit Dixit, Advocate and Cyber Law Consultant, and brother and sister judges from Rajasthan and other high courts, judges from various districts, lawyers. As I stand now, it's 5 past 1. The session was supposed to start at 12. And the lunch break is 1:30, so we have half an hour. So I requested organizer to extend it by another half hour because we're very eminent speakers here. Because judges are used to speak, in all these conferences by virtue of their position, not so much by their caliber. But we will request the other experts here to spend more time. In fact, as I stand, I just was recollecting what to say. I remember when I was a student, I was traveling by train, student not of law, in a graduation Delhi University. I was asleep in a train. Around 1 o'clock, I heard a shout, Mera sher, mera sher, mera sher. I was wondering because, see, my Hindi is limited. I said, Mera sher, isme train mein sher lion ka kya hai? So I was wondering. Then because I woke up and said, Kya hua bhai? What is this happening? You're shouting Mera sher, mera sher. But it appears that his share, that certificate was stolen by somebody when he was asleep. And obviously he's shouting because you won't know once it is stolen in railways, you know what is the fate. Because every station there is a stoppage, you won't find out. And you can't, go and ask him, Mera dikhao, mera tumhara suitcase kholo. So what I'm trying to say is that today you don't have that problem because all digital now. The share, how we have transformed ourselves, and also how we have transformed ourselves, our individuality also. पहले ज़माने होता था आपका आइडेंटिटी कार्ड वही फोटो वाला आई कार्ड इशूड बाय योर कॉलेज और हो गया बस पास भी आई कार्ड बट दैट आई कार्ड हैज चेंज्ड tremendously today. Today's iCard is not mere photo. Your iCard is your iris photos. Your iCard contains your fingerprints. Therefore, you are not identified by your mere physical appearance. कि आप तो बहुत smart है, आप तो बहुत सुंदर है, आप तो वो है, so people can remember. But it goes beyond it now. It has transcended a physical form of identity. It has taken a digital form which is much more. That's why we are all, that's why when I saw this invitation, I received invitation from the legal service authority of Rajasthan, and they were discussing about it. I heavily accepted, because even though I had some other request from other university, but I said I will give because I want to learn. Because see, as for us, most of us are sitting here, especially the High Court judges, we are in a different, we belong to a different generation. Except for the young lawyers and judges, perhaps from the CJM onwards, they belong to a younger generation. They are more familiar with the cyber and digital world. We belong to the older generation. And we actually, therefore, we learned our driving in ambassadors and Fiats, where you have to physically do everything, for change a gear, everything. Now today, you have all the cars, you all automatic and all various other cars you don't require. So what I'm trying to say is that similar thing, it has changed. Our cyber law also has changed dramatically. As I see, cyber law can be divided into two phases. Historical, हम लोग history पढ़ते हैं इतिहास में, ancient Indian, Middle Age, then Mughal age, then British, modern age, whatever, so and so forth. Cyber law, I would divide into two categories: pre-2000 and post-2000. For the simple reason that 2000 IT, Information Technology Act, which was enacted in 2000, brought a whole change in the law of cyber. Now, of course, as we understand, we think that this IT law is typical IT meant for all these issues. It is not actually. When IT law was enacted, it was enacted for the ease of business. They were not thinking so much about the cyber crimes, for which DIG Sahib is here to all these works. When this IT 2000 Act was enacted, they had in mind this ease of doing business, trying to an additional forum, because already it was all earlier this paper-based documentation, all commercial transaction, others. Because the IT Act was basically in terms of UNCITRAL, this model law, to bring it electronic communication as a mode of kind of transaction to ease it. So they were more focused in that. But fortunately, it has come in a long way to help in dealing with these issues, criminal laws, as we understand. So as I understand, the law before, also there were digital and electronic law relating to, for example, recording of evidence, tape recorders. In some of the cases, if you remember, Yusuf Ali versus State of Maharashtra in 1968, they said, the Supreme Court said, yes, you can use tape recording, recording evidence to corroborate or discredit or to contradict or impeach the credentials of the witness. Then same thing it followed in 71 also. We see MC Ramana Reddy versus VV Giri. Similar issue came up. The use of, at that time, technology was also very basic. Therefore, there was no issue which engaged the mind of the judges also. Our judicial system responded according to the problem faced. The problem was not as serious, as complicated as today. Therefore, our interpretation was also limited. Similarly, and in fact, the famous case of NCT Delhi versus Navjot Sandhu, that parliament case, the Supreme Court said, well, so much, because this is of course post-2000, and by the time 65B had come into existence, but the Supreme Court said, oh, so much of conditions, and no point, because we have to investigate, we have to convict. And if you are not able to get all the conditions fulfilled, no problem, you can go ahead. Because after all, 65 A says, well, may, B says, may, A. So first says it can be electronic evidence, may be also proved. Now, of course, there was a paradigm shift after that in the first judgment which overruled Sindhu was in Anwar, 2015. I say it is mandatory. I just was, just citing this, the evolution of law, that it is a mandatory provision, because it said it starts with this non-obstanted clause, notwithstanding anything. Therefore, they said, irrespective of what has been provided in other provisions of the Act, any Act for that matter, this is mandatory. Therefore, the whole evolution, it was upheld by the Supreme Court in Arjun Pandit, which will be, of course, discussed in detail by the Learned Counsel. Here I can see he's Dr. Nishit, also he'll be speaking on the contours of 65B. I will not speak much on that, but I can just what are the basic features, just for easy remembrance, that what is that, to be admissible, the electoral record, it must have been used, the source from which it is obtained, that it must have been used regularly. So used regularly, that's very important. Then number two, regularly fed. This data must be regularly fed into that system. It's not that once a while he walks in and he uses a computer once in a year or something like that. No, it should be regularly used. Of course, what is the meaning of regularly used? Of course, that has also not been very well defined. These are all grey areas which will, of course, the court has to interpret in a much more meaningful manner. Then operating properly. These are very important words, operating properly. Then it reproduces the record as in the original. So what we see is that used regularly fed, operating properly, and reproduces the record. So these four elements, what we call, somebody has very well described as U4. If you want to remember this, U4, because everybody knows U4. That unidentified foreign object, no? Flying object or something like that. You add R into it. So you remember these are the criteria which a certificate must always fulfill before it is admissible in law. Yes, there's some other aspect also. Of course, we'll be happy to listen to the experts who are here, especially we have with us Vikas ji, who is actually in the field. Because we judges we are not in the field. We decide what is brought to our notice in the court of law. And Vikas ji are the ones who collect all these materials. And of course, they have to be careful. What is the material they collect? In what manner it has been collected? These are all challenges, especially before the investigating authorities. How to certify, for example, a document based on Googles. What do you do when the Googles do not respond? There are challenges. It will be all tested in the court of law. The defense is going to challenge that your certificate, so-called certificate you obtained relating to a document obtained from Google Cloud or Yahoo Cloud or for the matter any other cloud has not been certified in accordance with 64B. There are challenges, they have to do it because they are the one who have to collect, and these certificates obviously as explained by the code, that this can be produced only at the stage, even at the stage of tendering evidence. See, at the time of investigation, we may not be able to get it, but as your witness testifies in the court, at the time of that tendering of evidence, if you are able to produce that certificate, that is good enough. That's what these are all interpretation by court. Of course, these areas of law have to be also understood by the investigators. It's very important. Well, what do you mean by? I was listening to some speech also. If we read the definition of electronic evidence, they mention electromagnet and all this, so and so and so and so. And what is then we have this pen drive, which we often use. Pen drive is a flash drive. It's not in the form of electronic, magnetic, or digital. Said how is it included? Then what will happen to that evidence which is produced in the form of pen drive? Because it does not technically, strictly fall within the definition of electronic evidence under the Evidence Act. So these are areas. What I'm trying to say is that these are unfolding areas where, especially in the cyber law, which because everybody, it has been spoken since yesterday, the extent and the vastness and the complexity of cyber world is so difficult that the law, and it takes a long time to catch up. And all this, we came in 2000. I mean, after a decade, the computer was introduced in India, if I remember, sometime in 80s by Rajiv Gandhi, during that time, 84 or something like that. I don't know, I don't exactly remember. From 80s, there was no law dealing with this kind of evidence. It came up only in 2000. I just mentioned also this 2000 Act was introduced not primarily to deal with this cybercrime, but to do for a betterment of the ease of doing business. But now we are in a situation where we have no other option but to deal with this façon. Now, what are the challenges? Challenges is that for especially judges who are all settled here, we are not police officers, we are not lawmakers, we are judges. What to do? Because ultimately we are going to decide the matters. How do we decide a matter without having a comprehensive knowledge of this technology itself? I must say with all frankness, I mean, some people may take objection to it, because when about 5-6 years before, I asked some of these district judges, "Madam, आपके पास email है?" तो वो कहते नहीं, email नहीं है। अच्छा, आपको कंप्यूटर दिया हुआ है? Yes sir. तो then I asked कि क्या करते हैं ये सर एंड मैडम लोग, कंप्यूटर फ्री में देते हैं? वो बच्चे लोग देखते हैं नेटफ्लिक्स। See, we have to get used to it. Now, of course, that's not the situation. Everybody is now very kind of savvy, tech savvy now. Things have changed, but we have to change. Our judges, we have to also, our knowledge is not only about the law, the technical law which is contained in the Evidence Act and also the IT Act, as the case may be. It is the requirement of the day is to know how it functions. It's so important to know, and that's because every day we have a cyber cases, complaint being filed by young girl saying that we had a friendship with this boy and he uploads this. He has taken pictures of our very private moments and he's going to upload. He's sharing your WhatsApp. How does this technology works? And as far as, of course, one good thing about 65B is that evidence, there is nothing called primary or secondary when it comes to electronic evidence. So long as satisfied is 4 categories, conditions of certification, as good. It doesn't actually, my understanding of 65B is that there is nothing like, because we all know in Evidence Act, traditionally we are told what kind of evidence we have. We have documentary evidence, we have oral evidence, then of course material evidence in terms of exhibits, especially in criminal cases we find the weapon of crime which was used, that is also evidence. Does it become, but it's not defined. But as per our Evidence Act, if you rely on something, if it is producible, best evidence, you have to produce it. That's a material evidence. But computer, all these issues now have been all covered by 65B. What I'm trying to say is that it's a time for all the judges to be not only well acquainted, but be a master of this technology. Without which, same with the investigators. I'm sure Sharma ji also expert in this technology, because otherwise you won't be able to find out where all this digital. Because I remember when Pulwama attack took place in 2019, when bomb blast, the investigator relied on digital evidence to pinpoint the culprit. From the videos which were there, it was found that all the videos were circulated, they were all morphed. But he went deep into this technology and found out that the video which was being circulated was a fake one, and he could identify from the IP addresses and all this aspect. So time that is not only the investigators who have to have the knowledge of the technology, but we judges must also have it. Otherwise, we will not be able to do full justice. We will not be able to appreciate the problem before us. So I think I've spoken more than I should speak in terms of time, because this is such a vast and area, constantly evolving area of law. And I would obviously be very happy to listen to other experts in the field here. With these few words, I like to thank the organizers, the Legal Service Authority, for giving me this opportunity to share a few thoughts on this subject. Thank you very much.
Thank you, Honorable. Thank you very much. May I now request Honorable Mr. Justice Ashok Kumar Jain, Judge, Rajasthan High Court, Jaipur, who is also a co-chair, to please come and share his views on identification, collection, preservation and presentation of e-evidence with special emphasis on CCTV footage, social media, WhatsApp messages and digital photographs, which is a very, very important session over here.
Good afternoon, everyone. Namaskar. Before coming to the issue, just I want to point you out two things. First is that not to be afraid of use of mobile, digital devices and internet. Why I am saying so is that it is there to boost our ecosystem, particularly business. If you want to become a poor, I tell you, just refrain using the facilities which has been created. So, not to be hyped from it. I just want to highlight एक छोटी सी बात. I just will be in Hindi and English, mix both. Just I want to point you out that total digital transaction per month in this country is 26 lakh crore. And that has been addressed by Payment and Settlement Act 2007. And the entire governance is of Reserve Bank of India. The entire system has been managed very well. It takes care of every kind of effort, what has been required to be done. There is no need of unnecessary creating a hype about cybercrime. The total loss of money is 0.17% of the total digital transaction. 0.17%. And as if you know about the business, 10% of the total turnover amount is the profit and 10% out of is the loss and sundry expenses. This is not even 1% of that. And the banks have already taken care of it. इतनी चिंता करने की जरूरत नहीं है. जिनकी जरूरत है, जो कल ऑनरेबल चीफ जस्टिस ऑफ इंडिया साहब ने बोला, हमें सिर्फ वो सोचने की जरूरत है कि डिजिटल अरेस्ट, इट अफेक्ट्स द लाइफ एंड लाइवलीहुड ऑफ इंडिविजुअल्स. वी आर टॉकिंग अबाउट personal right, infringement of personal right, the privacy, the other things which are going on. So as regard to minor cyber crimes are concerned, and if we are creating I say just a ecosystem, we are in fact acting against the business ecosystem. So that what I want to start with. Just a caveat from my side, not to be afraid of everything. Let it be. You redress, you ask the people to redress your grievances from the bank, from the consumer forum, from the court, whatever is possible. One of the lady judicial officer from Hanumangarh has asked one question. I just want to point out here that you see 106 and 107 of BNSS is sufficient to take care of everything. The power of 106 is with the police and 107 is with the court. Nowhere any SOP cannot put a doubt on your power as exercised under section 107 of BNSS. So you are well empowered under the law. This is what I want to put a caveat before coming to the issue I just want to point out that I'm not going to discuss the legal issues. I just will focus on what is required and what is been done in a reality. Just I will take you to one of the case which was considered by Supreme Court. That is Chandrabhan Sanap versus State of Maharashtra. Sir, this case belonged to Bombay. And a very fair, sir, I am sorry अगर आप उनमें बेंच में कोई रहे हो. सर नहीं मैं सर जस्ट एकेडमिक बात पर ये केस ऐसा था जिसके अंदर जो अपराधी है वो रेलवे स्टेशन पर अपराध करता है, ट्रेवलर लेडी है, उसके साथ रेप होता है और मर्डर होता है. पुलिस उसमें सारी सीसीटीवी फुटेज लेती, क्योंकि मेरा टॉपिक है सीसीटीवी, इसलिए मैं उससे शुरू कर रहा हूं. लॉ का फॉलोआउट क्या होता है मैं उस इंपैक्ट से बताना चाहता हूं. 2014 में जब ये केस रजिस्टर्ड हुआ, सीसीटीवी फुटेज ली गई, जो भी डिजिटल एविडेंस अवेलेबल थी वो पुलिस ने ली. केस फॉरवर्ड किया सेशंस कोर्ट को बॉम्बे. मुंबई की कोर्ट ने उसको कॉन्विक्ट किया 302 में, 376 में और 7 के अंदर उसको फांसी की सजा दी. डेथ रेफरेंस ट्रेवल हुआ बॉम्बे हाईकोर्ट की डिवीजन बेंच को. बॉम्बे हाईकोर्ट की डिवीजन बेंच ने उस डेथ रेफरेंस को अपहेल्ड किया. सुप्रीम कोर्ट में 2015 के अंदर ये अपील फाइल हुई उसके बाद, और 2025 में उसका डिसीजन आया. तब तक जो लॉ की पोजीशन थी 65B की और कलेक्शन ऑफ डिजिटल एविडेंस वो चेंज हो गई. We are day by day growing, we are understanding so many things. Day before yesterday I was in Bangalore and in one of the program that relates to Nari Shakti, we have discussed one of the judgment were recently pronounced by Supreme Court in case of Jain Kaushik that relates to rights relating to transgenders. A trans woman faced discrimination and Supreme Court evolved a theory of omissive discrimination. You were duty bound to take certain steps, you failed to take, then you committed omissions. You omitted certain things. That the liability was upon you to do a particular thing, but you failed to take steps. That's why the Supreme Court imposed fine of 50,000 not only on Union of India but state government and also the private educational institution that you failed to take steps under the Act of 2019. So we are evolving legal doctrines on day-to-day basis as we are facing the problem. Herein, after the larger bench judgment in case of Arjun Pandit Rao's case, the fate of the case is acquittal, as it lacks the mandatory requirement as prescribed under the case of Arjun Pandit Rao. Earlier, as Honorable Lordships have discussed the earlier position of law pre-2020. On the basis of this, the conviction was held by the Sessions Court and upheld by the division bench. The position of law certainly resulted into an acquittal in a very well-proved case before the trial court. Of course, the issue pertains to circumstantial evidence. Birdhichand Bhagwandas Shada is the case whereby the Supreme Court has prescribed certain guidelines and on basis of that the district court, the sessions court and the division bench held that yes, the parameters are complete. But as regard to chain of evidence to prove the circumstances that was digital in nature and it was held that yes, no, these are not complete as per the law mandated under the Indian Evidence Act. So that was the case, and from that point I just want to point out few things which I feel that will be useful for all of you. I am refraining myself from using any legal language as far as possible. You see, there are two types of record. A record which you normally know, that is, one is electronic record and that is another is digital record. These are two different aspects. First is electronic record. What is electronic record? Data created, stored, transmitted via electronic system, part of a broader communication platform. This is what the electronic record is. And the example of these are email, SMS, web pages, and Excel linked to the system. The second is the digital record. What are the digital records? The files in digital form, either originally digital or digitized in physical resources. They are PDF, scanned images, MP3, MP4, Word files. Now there are several cases which travel to the magistrate that relates to email and also the production of printouts from certain sources, say from computer, from WhatsApp, from Telegram or any other thing. There are challenges, no doubt about it, that the perpetrator is in other country, but I tell you, if I commit a crime by sitting here, my location will be traced in Cambodia. This is very well possible. I have to use Tor browser and a system, hardware which is nowhere being registered in my email account. Even the internet of this RIC or the Airtel will not detect me that I am here. This is what the issue is. Nobody can. It will easily say that I am in Cambodia, but in fact I am in India. It is like this. So this all depends upon how this happened. In fact, I tried yesterday evening when Mr. Atriji told me that if it is possible to give up some presentation, I thought that how the collection of data is made. So I tried to contact one of the agency in Bombay, but yesterday they were engaged with IT team and ED team in one of the search, and they say, sir, we cannot compromise by engaging ourselves in presentation because we are already in a team. So then even if he pointed out one issue, he said one of the person who was detained by the IT income tax department, he was having Samsung S23 Ultra, and it is 11 hours since then we are working to transfer his data and is still not able to transfer the data. Though we are using MD software, that is again a Korean software. In 2014-15, when I was part of one of the certificate course in Lal Bahadur Shastri Academy on cyber crimes, then at that time we were taught on Paladin software. Nowadays the days of Paladin software has gone. Many more softwares are there, and I will list a few of them, and they in fact very methodologically detect the data. Like anything, even if you have scrapped and locked the phone, even if everything, except for the newer version of iPhone, everything can be detected and it can be decoded, except that For example, iOS 26.1, 26.2 still the cyber forensics, they are unable to detect the code. So it all depends upon, that's why people say if you want to remain safe, please don't click on unknown emails, unknown links, or don't respond to unknown phone number. In fact, what we have enabled our settings in a manner, if anybody call from unknown number, then automatically it is rejected. Only the persons in my contact list can contact me by any number. They cannot contact no unknown number. So I am out of the phishing network of anyone. Nobody can. So these all are, the security feature is there. If you are indulged voluntarily in phishing or anything, then you can become a victim, otherwise not. So the atmosphere is quite safe. It is not necessary to put a more vigil what has been required. I say, if you want that, if you want to remain in a safe atmosphere, please follow the protocol. That is all required. सावधानी हटी और दुर्घटना घटी, यही सिद्धांत यहां पर लागू होता है. The issue before us is collection and preservation in digital forensic investigation. First is identification of digital evidence. Identify the device and media that may contain relevant evidence. Securing the scene. Documentation, chain of custody has already been discussed, legal authorization, digital forensic toolkits, forensic imaging, hashing is very important, documentation of procedure, evidence packaging, safely transporting. Here I want to point you out because some of the police officials are there. I tell you, they only create one cloning device of the main device so as to distort the data. In fact, it requires two. One is master device and second is workable device. Master device has to be sealed then and there, and it has to be used only when court demands. And this is the common mistake committed by everyone. They have only one device with them. And moreover, they seal the original device as it is without cloning it. As soon as you open the device, the hashing and the value has to be same as it is. So there has to be system of integrity. Integrity should not be compromised at any point of time. The basic of the forensic is when two things came in contact with each other, they leave their impression on each other. If a device has been used for any purposes, in any careless manner, deliberately or without any reason, then it can change the hash value and further compromise the integrity. There has to be a documentation of storage, data verification, that I already talked about it, backup copies, legal documentation. One more thing which I want to point you out about the three specific objects which are produced before the court. First is the CCTV footage. You see, there are chances of editing and overwriting. The solution is forensic copy at seizure, hash at stages, 65B certificate from technician. when somebody uses seizes original DVR, a copy of that has to be procured immediately by using any of the software. Last one is the digital photos. There are chances of metadata loss, chances of editing. So the solution is original file secured with EXIF, expert hash report. These are essentially required. I just want to point out few tools which are used. Mostly there are two tools which are used. One is Celebrite UFED. This is an Israeli software currently used by the expert in the country. Second is American software, Magnet Oxim. This is used for iOS and also for cloud and also for this Android. Mobile devices, SIM card, mass storage, camera, quick copy, etc. Everything is possible. Again, mostly used software is, one of the most used software is Oxygen Forensic Detectives. Again, Mobile Edit Forensics. Belkasoft Evidence Center X. MSAB X-ray, and for Androids, particularly Samsung devices, normally used is MD Next. There are few more, but these are the important softwares which are being used for collecting and storing the digital evidences, transferring and also the analyzing the tools. Thank you very much. Jai Hind.
Thank you very much, sir. Now, may I please request Shri Vikas Sharma, IPS Deputy Inspector General of Police, Cybercrime, Rajasthan. Sir, we would like to have the detailed discussion from your side, as Lordships have actually asked you, being a subject matter specialist. So detailed one, please.
Thank you. Good afternoon, sir. Honorable Justice Prasanna, sir. Justice and Kotiswar, sir. Honorable Justice Ashok Kumar Jain, sir. Honorable Judges of the High Courts. Honorable District and Session Judges and Honorable Judges from the respective districts, sir. Sir, I've been given this topic about admissibility, appreciation and relevancy of electronic evidence with special emphasis towards the recently enacted Bharatiya Sakshya Adhiniyam 2023, sir. So the honorable judges have touched upon this subject, that how important it is to have a very good ground regarding the seizing of electronic and digital evidences and making them a part of evidence in such a way that the accused does not get benefit. The accused does not get benefit, and the work that has been done by police is thrown to zero because of certain lacunas that we can do while seizing our evidences, while properly packaging it, maintaining the chain of custody, and then presenting it before the honorable courts. So, sir, this particular act that has come has tried to address the various things that have come up with the advent of technology, and how we should be working on towards making our evidences part of proper perusal before the honorable courts. Sir, as sir has also told, sir, electronic evidence, including digital evidence, is any information which is stored, transmitted electronically or digitally. Commonly, it includes computer data, audio, video, text, messages, pictures. Now it is also using location services also, which is coming as a new thing that is becoming a part of our digital evidences. And it serves as a digital proof, while it has a very good advantage that it cannot be altered if it is produced before the honorable court in a very proper way. But side by side, it is very, very important that it is stored properly, it is produced before the forensic department properly, and then the forensic report along with all requisite certificates that I'll talk about later are produced in a fair manner. So the new criminal law, Bharatiya Sakshya Adhiniyam, has tried to bridge this gap where we were lacking in the certification part, and later on we'll come to see that they have given a very clear mandate about what should be the job of an expert, what should be the job of the seizing officer. So the foundation of this particular act is the IT Act. This was the first act to recognize what is an electronic device or an electronic record and how it should be used. The categorization of that particular evidence as an electronic evidence was started from the amendment that had come, and it was governed by the later amendment in the repealed Indian Evidence Act as 65B certificate, which most of us were using, but now it has come as 63 BSA with more enhanced ways of procuring that evidence and securing that evidence. So the modernization of this evidence law has made the scope of securing digital evidence more broader, sir. Now, initially the Indian Evidence Act did not contain electronic or digital record per se. But in this particular act, it has been quite clearly maintained that electronic and digital records have the same legal sanctity as a document. Whatever document that we had mentioned in our the definition of document that we had also covers the electronic evidence now. So the email logs, server logs, cloud data, locational data, all these are now a part of evidence and can be produced before the honorable courts. And they hold the same legality, and they are the same in enforceable as physical paper documents. Sir, for any evidence to be of any use, it should be relevant, it should address to the fact in issue, and it should give proper evidence about how the crime is being committed. Like we see in case of cyber crime, where a mobile phone or a computer system or any digital device is a main component which from which the cyber crime is being committed. It is the modus operandi of the committing the crime. So we should be able to properly, as sir has mentioned, make a proper clone copy of that, so that that clone copy should be used in investigation. The primary evidence which we recovered from the scene of crime should be stored in there, and it should be sent to the forensic department as soon as we can without unnecessary delay. And on that clone copy, we should work with our available softwares and our available investigative tools, and then cull out information from that particular device, take a proper certification from the official people and present it before the court. Sir, the expanded definition has given relevancy to the logic that now a GPS log also qualifies as a document, because it has been explicitly stated in the new act, sir. Sorry, sir. Sir, the general rules of admissibility, sir, that it should be logically relevant to the case obtained. It is very much a common sense thing, sir. It should be the original evidence, sir. Sir, there are two things in the evidence that has been put in the new criminal act. It is that there are going to be primary evidences and secondary evidences. So any original evidence is considered as a primary evidence. Original evidence means if my phone is being used to commit certain crime, so my phone is a primary evidence. It does not need any certification from any other person except when the IO has seized the original device and made a proper copy with proper hashing of the mobile phone, written in the proper form of a memo and then present it before the FSL department, sir. So copies are secondary evidences, but they have to be very much certified in the way that has been provided in this particular law, that how do you make a copy of it, how do you certify it so that it is the chain of custody is maintained and there is no allegation of tampering on that particular secondary evidence that you are presenting in the court. And yes, sir, it is still a learning process for police that we are working on how to the secondary evidences particularly, because most of the cases we find these secondary evidences. So how to make the secondary evidences as a part of our investigation in a very, very cogent and legal way, sir. Sir, the key provisions of the new act. ये एक बार सर ये टीवी बंद हो गया तो दिखाई नहीं रहा मुझे. Sir, I can. Sir. Yes, sir. Sir. Sir, section 61 of this act, sir, it has given the main teeth to the collection of evidence and categorization of evidence, so that any digital evidence cannot be simply rushed away because it is a digital evidence. So digital evidence has the same evidentiary value which earlier other documents or oral evidence, proper oral evidences had. Yeah, sir. Sir, the section 63 has further expanded it, sir. Even the devices like semiconductor devices, sir, which are mainly storage devices also, optical media devices, sir, if they are also properly in the form of evidence as specified, they can be considered as primary evidences and are in the same boat as a documentary evidence. So the act has given a very wide scope to the definition of a digital device, and anything which can be used as a communication measure, as a measure of storage, as a measure of transferring information electronically can now be a part of as a digital evidence under this act, sir. And section 57 has also broadened this definition of primary evidence. The thing that is in custody of a person becomes primary evidence if it is produced in that way only, sir. Sir, section 59 of the act defines that there will be a secondary evidence. Earlier, sir, the thing that has changed from the Indian Evidence Act was this specific introduction of particular evidence as a secondary evidence, which was not specifically there in the 65B earlier or the Indian Evidence Act earlier. So now primary evidence and secondary evidence are defined in black and white in the law, and they become part of what should be the proper way of investigation of a particular case, and we are working on the SOPs so that these particular the steps that are required in this are followed properly, and the courts will not have any pain in because we sometimes interact with our honorable judges, and we find that because of certain very minute procedural lapses, some cases which should result in conviction end up getting acquitted, sir. So Nitish sir also is here, sir. We have interacted with him also, and he is also given us certain points which can become a part of our SOPs, so that our field officers can work on it to identify primary and secondary evidences properly, sir. Because sir, what happens with police is we do a very good job till the where the crime is to be cracked. So there we stop. Then the next part is how to make it in a proper evidence and present it before the court. We mostly lack in that. That is one of the reasons for lower conviction rates, and with everything becoming digital now. So with each and every case, we'll have to have more focus on this particular type of collection of evidence, sir. Sir, as secondary evidence has to be admitted with particular directions as given in the section 65 of the section 63 of this new act and 65B of the earlier act. So these are the criteria for admissibility and certification. 63(2) mandates that electronic record must be formally certified. They should meet the standards of reliability and integrity to the satisfaction of the court. If it is a computer system, the data extracted from the computer system should be free from tampering or digital imperfection or digital mutation in that. 63(4) is where the detailed certificate and the performa for detailed certificate has been given, sir. The certificate can be produced by the person who is in charge, and a second certificate by an expert that has been mandated by law. It is 2 parts. This certificate is to be generated. Part A is one person who is actually the producing party of that certificate. If it is a primary evidence, then that particular Part A certificate and that certification by an expert in Part B certificate. If it is a secondary evidence, then for that secondary evidence, first that proper chain of custody has to be maintained, then will come the Part A certificate, then will come the Part B certificate, sir. So I'll have 2 or 3 minutes on this Part A and Part B, sir. Part A is basically, sir, the person who is actually having that particular digital information or digital device or digital thing, that has to be part of the investigation, sir. And Part B is an expert evidence which certifies that the information that was taken in Part A is untampered. He does it by using something called as a hash value, sir. This hash value maintains the integrity of that evidence. As soon as I put something else in that particular evidence, primary evidence, the hash value will change. So if I go to the court with that tampered evidence, the defense lawyer can easily ask that hash value when it was seized was something else, and now it is something else. So this means that something had been added or deleted or altered in that particular evidence. So maintaining that hash value and giving it by an expert is the main crux of this new law, where the threshold of our evidence will improve as it is given by a particular expert in that field, sir. We are in process of recruiting forensic investigators also, sir, who will give these hash values. Our state has recently given 50 mobile vans to each district, where this particular thing will come up slowly in our working, sir. So though this is the strict certification, it has to be 2-part certification. Part A from the party, it may be police, it may be the person from whom we are seizing, it may be the person who is giving a secondary evidence with proper chain of custody. And Part B is completed by an expert using specific algorithms. Sir, our government has trained and declared 384 constables. Our Home Department has done it, sir. These are Part B certified experts. It is to bridge the gap till time the forensic capabilities reach to the level where we can have a particular IO in the field with a particular forensic investigator to give these hash values, sir. Sir, bank servers, iCloud data, Google Sheet data, all these data are treated as primary evidences unless they are disputed during the course of investigation or trial. So primarily the data that we are receiving from servers like Google or Apple, primarily it is a primary evidence unless there is a question mark over that is during the course of trial it may come that this particular evidence is being fabricated. Then we can go to the particular service provider and ask for certification from them. Sir, chain of custody is very, very important as in all evidences. So, but with digital evidences and the now proliferation of such crimes where digital evidence is the key, it is very, very important that we have a strict chain of custody. Collection, control, transfer, analysis, everything has to stand the test of the honorable courts. So algorithms like SHA-26 or MD5, sir, these are industry grade algorithms which generate hash values. So these create a very unique digital footprint, and that particular evidence will have a very unique signature of it if it is properly hashed. Any alteration to any file, even if I put it into the system and maybe just copy some part and I don't even alter the data, but even copying itself will alter the hash value. So if properly it is done, it will be a very good way of presenting evidence in the court. The court can appreciate by first evaluating the Part A certificate, whether the Part A certificate is generated properly so that the chain of custody is established, and then the Part B certificate for authenticity, that the hash value is proper, the hash value has not been changed, and the digital evidence has not been altered, sir. Sir, thank you, sir. This was all from my side, sir, and I really thank Ralsa and Honorable High Court for giving us this opportunity, because this per se is a new field for us, sir. How to present the evidence in court is a very challenging part for police, and hopefully we can learn from such interactions, and the other side also comes to us that this is your errors, you should rectify on them. Thank you, sir. Good day, sir.
Thank you very much, sir. It was quite interesting and informative session. However, I will request you, the way I saw honorables writing down all whatever you were mentioning, if you could give a copy of each to each, that will be quite helpful. No, I'm saying that the way I saw honorables writing down whatever you're saying, so if you could give a copy of each, to each the honorable, that will be quite helpful to them. Thank you very much. Now, may I please request Dr. Nishit Dikshit, advocate and cyber law consultant, to speak on the contours of Section 65B in the light of Arjun Pandit Rao Khotkar versus Kailash Kushan Rao Gorantyal. This is the last, discourse on it, but the most interesting definitely was he comes from the field. So I will request everybody, especially the new students of the law, to be very, very careful and attentive to listening to it. Thank you.
Thank you, sir. Pranam sabhi ko. Dignitaries on a dais, dignitaries of the dais. लास्ट में डिफेंस को बुलाया जाता है क्लाइमेक्स के लिए, तो मैं समझ रहा हूँ शायद मेरे को इसीलिए लास्ट में रखा गया है. To be very frank, we are talking about admissibility of electronic evidence. Forget about it. 90% cases we can easily solve. 90% we can secure conviction if we are totally taking original device. We are relying only admissibility, but we have to take care of about authenticity of electronic evidence. हम सिर्फ admissibility पे भाग रहे हैं 2000 से, हम उसकी authenticity की बात नहीं कर रहे हैं. मुझे किसी ने एक चैट किया, मुझे एक व्हाट्सएप मैसेज भेजा, I took the screenshot, मैं आयोग के पास गया, this originator has sent me this WhatsApp message. What I will do? I will take the screenshot. आयोग क्या कहेगा, आप screenshot दे दीजिए, 65 भी दे दीजिए. It is admissible. It is admissible. WhatsApp screenshot is admissible as far as Indian law is concerned. Screenshot plus 65B. Now, what is the challenge? Whether this originator sent me this content or not, whether his mobile phone was confiscated or not, whether it was forensically examined or not. It might be possible I am using fake WhatsApp generating messaging applications. It's now available. मैं उसको साथ 3 चैट में से 1 चैट मैंने चेंज कर दी. If you go through, आप खुद भी देख सकते हैं फेक व्हाट्सएप जनरेटर एप्लीकेशंस. आप उसमें एयरटेल है, अगर उसका फोन वोडाफोन का है तो मैं इसमें वोडाफोन फ्लिक कर दूंगा, उसकी डीपी लगा दूंगा और सेम चैट्स लगा दूंगा जो चैट्स उसने किए जस्ट पहले की चैट. उसमें मैं टाइमिंग डाल दूंगा 3:21 AM, यानी सुबह 3:21 में उसने मुझे चैट किया. आई एम रिलाइंग ऑन एडमिसिबिलिटी. द मोस्ट इंपॉर्टेंट पार्ट इज द ऑथेंटिसिटी. Sanjay Singh Rao Chauhan versus Datta Rao Gulabrao Phalke, 2015 Honorable Supreme Court. Very landmark judgment as far as source and authenticity are 2 hallmarks of electronic evidence. हम law enforcement agencies की with due respect गलतियां वहीं हो रही हैं because we are not confiscating primary evidences. हम digital device ले नहीं रहे. Like CCTV sir has covered. If you go through by the landmark judgment of Delhi High Court, Kishan Tripathi versus State of NCT 2015. Twin fold test. You have confiscated CCTV footage, the honorable court has to identify the person कि ये लग रहा है नहीं लग रहा. हाँ, बस इतना ही honorable judge का काम है कि yes ये लग रहा है या नहीं लग रहा. It has to be forensically examined by the forensic lab. Twin test. First is the integrity of this device. The device का जो technical part है उसमें तो कोई manipulation नहीं है. Second is the content related. क्या वो CCTV में कोई manipulation record में तो नहीं है. तो ट्विन टेस्ट के लिए कृष्ण त्रिपाठी में क्लियर किया गया. वेरी लैंडमार्क जजमेंट ऑफ ऑनरेबल दिल्ली हाई कोर्ट. अगर सीसीटीवी कहीं किसी विक्टिम के यहां लग रहा है तो क्या वो मना करेगा कि आप मत ले जाइए डीवीआर हार्ड ड्राइव? कौन मना करेगा? यू हैव टू कॉन्फिस्केट प्राइमरी एविडेंस. आपका केस हमेशा स्ट्रांग रहेगा क्योंकि इट हैज टू बी ओनली फॉरेंसिकली एग्जामिन्ड. सीधा भेज दिया आपने, नो 65B पार्ट ए पार्ट बी, किससे लेना नहीं लेना, हैश वैल्यू कौन सी. इट इज द duty of the forensic examinations. You just confiscate, send it to FSL. The forensic will do their job. If the system is installed in accused house, again, उससे भी क्या वो बार्गेन थोड़ा करेगा, सब 65 भी ले लो. Accused से तो वैसे भी 65 भी नहीं ले सकते. सेल्फ इंक्रिमिनेशन तो आपको प्राइमरी सीज करना है. तो गलतियां हमारी ग्राउंड लेवल पे है लॉ एनफोर्समेंट एजेंसीज से. थर्ड पार्टी, ये चैलेंज है. थर्ड पार्टी मींस नीदर ही इज एक्यूज्ड नॉर ही इज विक्टिम. उसके घर के सामने मर्डर हुआ है, अब उसके यहां सीसीटीवी लग रहा है. प्रैक्टिकली क्या होगा? सिविलाइज सिटीजन के रूप में आयोग मांगेगा, भाई आपके यहां सीसीटीवी लग रहा है, प्लीज हैंड इट ओवर. वो कहेगा सॉरी सर इतना महंगा है, आप क्यों ले जा रहे हो मेरा. बट बेस्ट एविडेंस रूल यू हैव टू फॉलो. आयोग को थोड़ा स्वार्थी बनना पड़ेगा. फॉरगिव माय लैंग्वेज. आयोग को स्वार्थी इसलिए बनना पड़ेगा बिकॉज इट इज हिज केस. और कहीं मर्डर हुआ है, स्टैबिंग हुई है, और he has to issue the notice. आपको बाद में क्रॉस में पूछा जाएगा कि क्या किसने, आपने मांगा क्यों नहीं, प्राइमरी एविडेंस अवेलेबल था, why you didn't confiscate it. किसने मना किया था आपको देने के लिए. के रामाजयम का बड़ा इंपॉर्टेंट जजमेंट था मद्रास हाईकोर्ट का 2016 में, जिसमें ऑनरेबल मद्रास हाईकोर्ट ने कहा था सबसे पहले इट इज द ड्यूटी ऑफ द आयोग टेक द प्राइमरी एविडेंस एंड कंपनसेट. स्टेट गवर्नमेंट हैज टू कंपनसेट ऐसी स्टेज में. और दिल्ली पुलिस 2017 से दे हैव द स्पेशल नोटिफिकेशन ऑफ 448 और दिल्ली हाई कोर्ट में उन्होंने सबमिट किया उस पूरे एसओपी को कि दे आर सीजिंग प्राइमरी डीवीआर हार्ड ड्राइव फ्रॉम द थर्ड पार्टी ऑल्सो एंड दे आर प्रोवाइडिंग न्यू डीवीआर हार्ड ड्राइव. सिंस 2017 दे हैव स्पेशल सेल इन दिल्ली पुलिस कि वो थर्ड पार्टी से लेते हैं डीवीआर हार्ड ड्राइव और उसको नया देते हैं. सर अब आप बताइए कहाँ मुझे 65 भी चाहिए, कहाँ मुझे एडमिसिबिलिटी के पीछे जाना है. मेरा केस तो 100% अगर मैं रिलाई कर रहा हूँ डिजिटल एविडेंस में 100% कन्विक्शन में जा रहा है अगर इफ आई एम डिपेंडेंट अपॉन दिस डिजिटल डिवाइस. दैट्स अ वेरी इंपॉर्टेंट पार्ट. वी ऑल आर लिविंग इन डिजिटल इरा. जो डीएनए था, स्वेट था, सीमेन था, हेयर है, टूथ है, अब वो बिल्कुल डिसअपियर हो गया है. नाउ यू हैव डिजिटल डीएनए. व्हाट इज डिजिटल डीएनए? दैट इज 01 बिट्स एंड बाइट्स. If I am using this phone, this is smartphone, but I am not smart. This mobile is smart. This smart people uses this phone. सबसे स्मार्ट फोन ही अगर देखा जाए तो स्मार्ट पीपल फोन. बिकॉज अगर मैं इससे क्राइम करता हूं तो ओनली CDR विल बी अवेलेबल, कॉल डाटा रिकॉर्ड. बट इफ आई एम यूजिंग दिस फोन, इसमें मेरा CDR भी आएगा और IPDR भी आएगा. मैंने बहुत से केसेस देखे एज ए डिफेंस लॉयर जिसमें विक्टिम क्रिमिनल ने इस फोन को यूज किया और इन्वेस्टिगेटिंग ऑफिसर ने सिर्फ CDR लगा रखा है. CDR लगा रखा है, वाइप कॉल चल रही है उसकी, रात को 12 बजे बाद मर्डर हुआ है और उसका 9 बजे बाद कोई CDR नहीं है. आयोग कहता है सर 9 बजे बाद तो इसने बात ही नहीं करी, CDR नहीं है, ये तो वहां है ही नहीं. अरे भाई वो 9 बजे के बाद वाइप कॉल कर रहा है, यानी व्हाट्सएप कॉल कर रहा है. व्हाट्सएप कॉल का डाटा CDR में नहीं आएगा, IPDR में आएगा. इंटरनेट प्रोटोकॉल डाटा रिकॉर्ड्स 90% वी आर नॉट एबल टू आइडेंटिफाई IPDR. 16 कॉलम्स होते हैं. अभी एक मर्डर हुआ बंगाल में, उसमें लेडी ने अपने हस्बैंड को वीडियो कॉल किया. लास्ट कॉल थी हस्बैंड वाइफ के बीच में. वाइफ ने सिर्फ वीडियो कॉल किया. वीडियो कॉल में 2 सस्पेक्ट दिखे उसको साथ में, जो उनके साथ खड़े थे. इन द सेंस उसने माना फ्रेंड्स होंगे. उसके बाद उसकी एक मार्शी वाटर में डेड बॉडी मिली. इन्वेस्टिगेशन स्टार्ट हुआ जस्ट बिकॉज ऑफ द IPDR. लास्ट जो है, हमें IPDR नहीं समझाया जाता. टेक्निकली आईओस को, ऑनरेबल जजेस को, प्रोसिक्यूशन ऑफिसर्स को IPDR पूरा पढ़ना आना चाहिए बिकॉज द मेजर पार्ट इज द IPDR. आज क्रिमिनल CDR यूज नहीं करते, सिम की भी जरूरत नहीं है, इंस्टेंट सीधा वाईफाई. उस IPDR से क्या आइडेंटिफाई होगा कि जो वाइफ था, वाइफ का जो IPDR निकलवाया तो सोर्स IP और हस्बैंड का डेस्टिनेशन IP मिल गया. यानी यस, वाइफ ने फोन किया था हस्बैंड को. और सबसे इंपॉर्टेंट पार्ट होता है जो हम एडिशन देखते हैं, पोर्ट. What is port? Port is we have 65,535 ports worldwide. Suppose आप सब यहाँ हैं और हम RIC का वाईफाई यूज कर रहे हैं, and I did something unlawful activity. So RIC का जो राउटर इन्वेस्टिगेशन बोलते हैं RI कैन आइडेंटिफाई कि इतने सारे लोगों ने वाईफाई कनेक्ट था, बट कौन सा मैक आईडी, मशीन आईडी था जिससे क्राइम हुआ है. दिस इज द ब्यूटी ऑफ इन्वेस्टिगेशन. बट क्या हम डीप डाइव इन्वेस्टिगेशन कर पा रहे हैं? जस्ट सीडिया ले लिया, खत्म कर दिया. आयो पे वैसे प्रेशर है 60 दिन के अंदर सर अक्यूज अंदर है, 60 दिन है, 90 दिन है. सबसे ज्यादा अक्यूज आयो खुश होता है जब उसकी बेल हो जाती है. चलो सर रिलीफ हो गया, अब कम से कम भागना नहीं पड़ेगा, 60 दिन 90 दिन. ये चीजें नहीं फॉलो करनी है हमें सर. ये सबसे बड़ा चैलेंज है. अब सीसीटीवी है, अब सीसीटीवी इंस्टॉल्ड है और आयो ने कहा सर शक्ल नहीं दिख रही थी तो हमने कॉपी नहीं ली. अरे किसने कहा था आपसे? यू हैव गेट पैटर्न एनालिसिस. गेट पैटर्न एनालिसिस ली. मैं मूव करके आ रहा हूं, मेरे चलने का तरीका रिकॉर्ड है, बट मैंने मास्क किया हुआ है. गौरी लंकेश का मर्डर हुआ कर्नाटका में, बेंगलुरु में. शी वाज जर्नलिस्ट, वो हेलमेट पहन के गया, मर्डर करके आया, बट हिज वॉकिंग पैटर्न वाज कैप्चर्ड. स्मार्ट पुलिसिंग इसे कहते हैं. उन्होंने किया, उन्होंने आइडेंटिफाई किया, सस्पेक्ट्स को चला के टिप कराया, आइडेंटिफाई किया, गुजरात फॉरेंसिक लैब को भेजा. गुजरात फॉरेंसिक लैब ने कहा कि यस ओरिजिनल वीडियो इनमें से इसकी वीडियो सेम है. गेट पैटर्न एनालिसिस. सो ये नहीं है कि हम फेलियर नहीं. यू कैन डिग आउट. अगर आयो ने सोच लिया कि मुझे इसको इन्वेस्टिगेशन को प्रॉपर करना है, यू हैव सोर्सेज. ये सबसे इंपॉर्टेंट पार्ट है गेट पैटर्न एनालिसिस. बॉम्बे हाई कोर्ट, बॉम्बे कोर्ट में पॉक्सो केस में सिर्फ उस गेट एनालिसिस से ही एक्यूज की आइडेंटिफाई हुई. सो मेरा रिक्वेस्ट ये है कि हम एडमिसिबिलिटी की बात मानते हैं, बट चैलेंज वहां है. सपोज यहां पर सीसीटीवी लग रहा है. अब मैं सीधा फंडामेंटल पे आता हूं. यहां सीसीटीवी लग रहा है और प्राइमरी एविडेंस हम कॉन्फिस्केट नहीं कर पा रहे हैं, तो अब क्या करना है? ये इंपॉर्टेंट पार्ट है. वहां सर ने जो बिल्कुल डिस्कस किया, पार्ट ए पार्ट बी, 63(4)(c) पार्ट ए पार्ट बी. 90% हमें ओरिजिनल डिवाइस मिल जाएगा. इट हैज टू बी सेंट टू द फॉरेंसिक एविडेंस. अब एक और चैलेंज है सर, यहां मैं पॉज दे रहा हूं. राजस्थान में और स्टेट्स में विद ड्यू रेस्पेक्ट सर, बिना कोर्ट की परमिशन से एफएसएल भेजा जाता है डिवाइसेस. अगर आप कर्नाटका जाएंगे, केरला जाएंगे, मद्रास जाएंगे, इवन उत्तराखंड जाएंगे, विदाउट कोर्ट परमिशन दे कैन नॉट सेंड टू एफएसएल. ये भी एक अपने आप में चिंता का विषय है कि ये क्यों ऐसा है. अलग अलग कोर्ट्स में, अलग अलग स्टेट्स में ये क्या इशू है. अब जैसे सीसीटीवी लग रहा है और ये वी आर अनेबल टू सीज डीवीआर हार्ड ड्राइव्स बिकॉज ऑफ सिक्योरिटी रीजंस. ऑनरेबल जजेस हैं, सीएम आए थे, डिप्टी सीएम आए थे. ऐसी स्टेज में अगर आरआईसी हमें नहीं दे रहा डीवीआर, सॉरी वी कैन नॉट प्रोवाइड ओरिजिनल डीवीआर, सो व्हाट टू डू. तो जैसे सर ने अजी सर ने बताया, वहां पार्ट ए पार्ट बी है. सो हु इज द कंट्रोल. अब बड़ा इंपॉर्टेंट पार्ट है. पार्ट ए में 4 पॉइंट्स हैं. ऑपरेट, ओनिंग, मैनेजमेंट एंड मेंटेनिंग. या तो कोई ऑपरेट कर रहा है, मेंटेन कर रहा है, मैनेज कर रहा है. तो इसमें से जो भी ऑपरेट कर रहा है या मेंटेन कर रहा है, ही हैज टू साइन पार्ट ए. अब प्रैक्टिकली मैं एक्सपेक्ट कर सकता हूं कि जो आरआईसी का मैनेजर है, जो मैनेज कर रहा है, उसको हैश वैल्यू लेनी आती है. सर्टिफिकेट में तो लिखा हुआ हैश वैल्यू, SHA-1, SHA-2 एंड अनदर. क्या वी कैन एक्सपेक्ट फ्रॉम दिस पर्सन टू प्रोवाइड द हैश वैल्यू? नहीं. तो जो पार्ट बी में एक्सपर्ट आ रहा है, he has to assist, he has to take the hash value. और हैशिंग इज नथिंग. हैशिंग सिर्फ वो कैलकुलेट करके बता रहा है कि यस इसकी इंटीग्रिटी अभी सही है, इसमें कोई छेड़छाड़ नहीं हुई है. बट मैं इस पे भी एक रैडर लगाता हूं एज ए डिफेंस लॉयर. अगर मैं आया किसी केस में, सो मैं कहूंगा कि 4 चेक पोस्ट हैं. इफ यू गो थ्रू बाय वेरी इंपॉर्टेंट लैंडमार्क जजमेंट ऑफ ऑनरेबल मद्रास हाई कोर्ट, युवराज वर्सेस स्टेट, रिसेंटली 2023, 4 check posts are available. First is the pre-acquisition hash value, then post-acquisition hash value, then post-forensic hash value. आज तक कितने डिफेंस लॉयर ने फोरेंसिक के बाद की हैश वैल्यू पूछी है? ये बड़ा इंपॉर्टेंट थॉट दे रहा हूं आपको कि हो सकता है वहां कॉन्टेमिनेशन हो गया हो. फोरेंसिक में बहुत से केसेस हमने देखे कि फोरेंसिक में कोई रिपोर्ट चेंज हो गई, विद ड्यू रेस्पेक्ट. बट मोस्ट इंपॉर्टेंट पार्ट, अब पोस्ट फोरेंसिक हैश वैल्यू के बाद वो कोर्ट की कस्टडी में वो डॉक्यूमेंट आ चुका, उसकी एफएसएल रिपोर्ट आ गई. 207 की एप्लीकेशन फाइल हुई. 207 में डिफेंस ने कॉपी मांगी कि सर मुझे कॉपी दी जाए. अगेन इट हैज टू बी एसर्टेन कि हैश वैल्यू इज मेंटेन और नॉट. बिकॉज एक केस हुआ है इंडिया में, फर्स्ट केस इन इंडिया, जहां कोर्ट कस्टडी में रहते हुए मेमोरी कार्ड की हैश वैल्यू चेंज हुई है. केरला का केस है, आप सब जानते हैं, वो बड़ा इंपॉर्टेंट केस है. इट्स ए सेक्सुअल असॉल्ट केस इन ए ड्राइविंग कार. सो ये एक बड़ा इंपॉर्टेंट एस्पेक्ट है. सो हमें इंपॉर्टेंस देनी है ऑथेंटिसिटी पे. अब यहां एक और चैलेंज आता है Section 45A, earlier Bharat Indian Evidence Act. Now it's Section 39 subsection 2, read with 79A of IT Act. ये इतना इंपॉर्टेंट केस है, इतना इंपॉर्टेंट सेक्शंस है, इसको हम बिल्कुल भी सीरियस नहीं ले रहे हैं. अगर आप पैरा 16 अनवर वर्सेस बशीर को रेफर करेंगे और पैरा 61 अर्जुन पंडित राव को रेफर करेंगे, दोनों ही ऑर्डर्स में, दोनों ही जजमेंट्स में ऑनरेबल सुप्रीम कोर्ट ने 79A लैब को जिक्र किया है. सपोज दो आज की तारीख में थैंक्स टू ऑनरेबल कोर्ट्स की प्रिजर्वेशन डिटेंशन को अर्जुन पंडित राव में ही सबसे पहले रिकॉग्नाइज किया गया था कि आप इलेक्ट्रॉनिक रिकॉर्ड तो है बट उसका प्रिजर्वेशन डिटेंशन क्या है. सपोज किसी ने सीडीआर मांगी और सीडीआर की सेकेंडरी कॉपी, ऑब्वियसली सेकेंडरी कॉपी आ गई, वो सर्वर पे है, उसका 65B के साथ आ गया. ये आप रेफर करिएगा अर्जुन पंडित राव को, वेरी इंपॉर्टेंट पैराग्राफ है उस जजमेंट में ऑनरेबल सुप्रीम कोर्ट का, जिसमें उन्होंने इस चीज को क्लैरिफाई किया, प्रिजर्वेशन डिटेंशन. सीडीआर की कॉपी मांगी, सीडीआर की कॉपी आ गई, बट आप समझ रहे हैं क्या वो प्रिजर्व्ड है, क्या वेदर प्राइमरी इज प्रिजर्व्ड. हमने सेकेंडरी एविडेंस ले लिया, क्या वो प्राइमरी प्रिजर्व्ड है टिल द लॉजिकल कंक्लूजन ऑफ द केस. ये एक बड़ा इंपॉर्टेंट चिंता का विषय है कि सेकेंडरी ले लिया, प्राइमरी डिस्ट्रॉय. ये कहां लिखा है लॉ में? तो कहीं लिखा नहीं कि प्राइमरी डिस्ट्रॉय कर दो, सेकेंडरी ले जाओ. कहीं भी ड्यूरिंग ट्रायल, ड्यूरिंग अपीलेट स्टेज पे अगर वो कहीं उसकी जेन्युइननेस पे क्वेश्चन मार्क लग गया, कोर्ट कहेंगे ब्रिंग द प्राइमरी, और यू कैन से लोकल कमिश्नर अपॉइंट करके आप चेक करिए प्राइमरी एविडेंस का क्या अवेलेबिलिटी है. जीरो आंसर. उसमें ऑनरेबल कोर्ट ने कहा 45A 79A लैब. इन राजस्थान वी डोंट हैव एनी लैब दैट इज 79A लैब. Triple E, examiner of electronic evidence. Kerala, we have 2 labs. Karnataka, we have 1 lab. Delhi, we have 7 labs. Rajasthan, we don't have a 79A lab. So what 79A, read with 39(2) says, when in a proceeding court thinks fit that court requires any expert opinion pertaining to any electronic record, honorable court can seek an expert opinion from the labs which have been notified by 79A. So Rajasthan की forensic lab 79A lab नहीं है. हमारे कोर्ट अगर कोई ओपिनियन लेना चाहते हैं इलेक्ट्रॉनिक रिकॉर्ड्स के लिए, लॉ रोकता है. IT एक्ट विद भारतीय साक्ष्य अधिनियम 39(2) रोकता है. वो साफ कहता है कि ऑनरेबल कोर्ट्स को अगर एक्सपर्ट ओपिनियन चाहिए है तो आप 79A लैब से मांग सकते हैं. तो ये एक बड़ा इंपॉर्टेंट चिंता का विषय है. दूसरा चीज आती है ओपन सोर्स इंटेलिजेंस टूल. देखिए एक और, अब मैं वापस से फर्स्ट सेशन पे आता हूं विद परमिशन. IT एक्ट को 25 साल हो गए, मेरे से 1 साल सीनियर है IT एक्ट. 2000 में IT एक्ट आया था, मैं 2001 से प्रैक्टिस कर रहा हूं, सो हमसे 1 साल सीनियर है. IT एक्ट को समझा नहीं गया, किसी ने ढंग से समझा नहीं. साइबर लॉज में IT एक्ट को समझा ही नहीं, बिकॉज वी हैव 3 कैटेगरीज. ऑल साइबर क्राइम्स आर नॉट कवर्ड अंडर IT एक्ट. ये डाउनलाइन पुलिस से भी गलती है, हम आगे फॉरवर्ड भी करते हैं इस केसेस को, प्रोसिक्यूशन से गलती होती है. सो वी हैव 3 कैटेगरीज. साइबर क्राइम्स पनिशेबल अंडर ओनली IPC और BNS. cyber crimes punishable under both IT Act and IPC BNS, and third is very important, where IT Act overrides IPC, that is section 81. So very important judgment अगर आप देखेंगे तो उसमें बहुत से केसेस लाइक अमन मित्तल, स्टेट ऑफ यूपी वर्सेस अमन मित्तल, सुप्रीम कोर्ट क्लैरिफाई किया है स्टेट लाइक वेयर स्पेशल एक्ट ओवरराइड्स IT Act. शरद बाबू डिगुमर्ती स्टेट ऑफ NCT 2016 सुप्रीम कोर्ट, वेयर IT Act ओवरराइड्स IPC. तो 3 कैटेगरी है, ओनली IPC केसेस भी साइबर क्राइम में आएंगे, IPC IT एक्ट भी आएंगे, और लास्ट में IT एक्ट ओवरराइड्स IPC. ये अंडरस्टैंडिंग हमें डाउनलाइन ऑफिसर्स को देनी है, और मैक्सिमम ऑफिसर्स रिलेक्टेंट होते हैं IT एक्ट लगाने के लिए, बिकॉज इंस्पेक्टर को इन्वेस्टिगेशन करना होगा, तो वो थोड़ा सा चैलेंज है. अमेंडमेंट होना चाहिए, स्टेट रूल्स भी कर सकते हैं, उसको अमेंड देखा जाए, रिक्वेस्ट कर सकते हैं. ये एक बड़ा इंपॉर्टेंट ग्रे एरिया है. अब एक आता है सबसे इंपॉर्टेंट पार्ट जो अर्जुन पंडित राव में भी क्लैरिफाई किया गया था, स्टेज ऑफ 65B. अब स्टेज में बड़ा इंपॉर्टेंट पार्ट है, देखा जाए तो फेयर ट्रायल में डिफेंस को वो सब डॉक्यूमेंट्स दिया जाना चाहिए जिसपे प्रोसिक्यूशन रिलाई कर रहा है, ठीक है, बट विद द कोर्ट परमिशन, इट इज द डिस्क्रिप्शन ऑफ द कोर्ट. कोर्ट में अलाउ टू फाइल 65B एट ए लेटर पॉइंट ऑफ टाइम. यू कैन रेफर सोनू वर्सेस स्टेट ऑफ हरियाणा, ऑल जजमेंट्स भी ऑनरेबल सुप्रीम कोर्ट में है. लेटेस्ट बड़ा इंपॉर्टेंट पार्ट है, और ये बड़ा इशू इसलिए है कि क्या ओरिजिनल एविडेंस कॉन्फिस्केट करने के बाद भी 65B की आवश्यकता है, जबकि ऑनरेबल सुप्रीम कोर्ट ने क्लैरिफाई किया ओरिजिनल एविडेंस इफ यू हैव कॉन्फिस्केटेड देयर इज नो रिक्वायरमेंट ऑफ 65B. बट कहीं कहीं एक स्टेज आती है कि एक्यूज से तो आप 65B ले लेंगे नहीं, एक्यूज का मोबाइल फोन सीज हो गया या उसका लैपटॉप सीज हो गया, उसको किसने ओपन किया? FSL ने. एफएसएल ने उसका आउटपुट लिया। अच्छा, दो तरह के एक्सट्रैक्शन होते हैं सर, ये भी टेक्निकल पता होना चाहिए। एक होता है फिजिकल एक्सट्रैक्शन, एक होता है लॉजिकल एक्सट्रैक्शन। लॉजिकल एक्सट्रैक्शन में डेटाबेस वो आता है जिसमें डिलीटेड फाइल नहीं मिलती है, और फिजिकल एक्सट्रैक्शन में होता है जिसमें डिलीटेड फाइल भी मिल जाती है। तो आईओएस को फिजिकल एक्सट्रैक्शन की ही इमेज कॉपी लेनी चाहिए। तो ये बड़ा इंपॉर्टेंट जजमेंट रहा ऑनरेबल सुप्रीम कोर्ट का। स्टेट ऑफ कर्नाटका वर्सेस टीन एसी, इट वाज बेंगलुरु ब्लास्ट केस। इन्वेस्टिगेशन टीम ने पूरा अच्छा केस स्ट्रॉन्ग बना दिया, बट ड्यूरिंग ट्रायल, अच्छा ये भी इंपॉर्टेंट पार्ट है, आप कब रेज कर सकते हैं 65B सर्टिफिकेट फाइल नहीं किया प्रोसिक्यूशन ने ड्यूरिंग ट्रायल, नॉट इन एपिलेट स्टेज। बट इस केस में ड्यूरिंग ट्रायल दे ऑब्जेक्टेड कि सर जो एफएसएल की रिपोर्ट है उसके साथ 65B सर्टिफिकेट नहीं है, बट प्रोसिक्यूशन ने उसमें 6 साल बाद सबमिट कर दिया 65B, और बाद में ऑनरेबल सुप्रीम कोर्ट ने भी उसको अलाउ किया लेटर पॉइंट ऑफ टाइम। बट यहाँ एक बड़ा इंपॉर्टेंट पार्ट है, क्या एफएसएल को 65B देना है? यस, बिकॉज दे हैव एक्सट्रैक्टेड सेकेंडरी एविडेंस फ्रॉम द प्राइमरी, उसके बाद किया। अब मैं प्रोसेस पे आता हूँ, गलती क्या हूँ। एक बड़ा अच्छा केस था, मैं एक जुडिशियल अकेडमी में गया था, वहाँ जज साहब ने मुझे बताया कि मेरे पास एक केस चल रहा है और बड़ा इंपॉर्टेंट है, फाइनल बस मुझे देखना है। मैंने कहा सर क्या था? मर्डर केस था, स्टैबिंग थी, और आयो ने अपने मोबाइल फोन से जो सीसीटीवी चल रहा है उसमें रिकॉर्ड कर लिया। क्लियर है सर? अपने मोबाइल से उसको रिकॉर्ड किया, लैपटॉप में लगाया, पेन ड्राइव में लिया, 65B इसने खुद का दे दिया और एफएसएल भेज दिया। एफएसएल से पूछा कोई टेम्परिंग है कि नहीं, कोई टेम्परिंग नहीं है, एफएसएल ने जवाब दे दिया। अब मुझे नहीं पता डिफेंस ने क्यों ऑब्जेक्शन रेज नहीं किया, बट मैं तो चलो ठीक है, तो क्योंकि उन्होंने जस्ट ओपिनियन ली थी, निश्चित जी इसमें क्या कर सकते हैं। मैंने कहा सर ये तो इसने खुद ने अपने मोबाइल से रिकॉर्ड किया, प्राइमरी एविडेंस किस में था? प्राइमरी एविडेंस तो उस डीवीआर जो सिस्टम में चल रहा है उसमें था, उसका फॉरेंसिक एनालिसिस होना था, उसकी कॉपी लेनी थी। ये एक सबसे बड़ा चैलेंज है। एक और इंपॉर्टेंट एस्पेक्ट है, मॉब लिंचिंग का केस था। मॉब लिंचिंग में आप जानते हैं लोग ही मारते हैं, लोग ही रिकॉर्डिंग करते हैं, तो रिकॉर्डिंग हो गई। रिकॉर्डिंग होने के बाद किसी ने उसको यूट्यूब पे अपलोड कर दिया, अपलोड ऑन यूट्यूब, आई डाउनलोडेड दैट कंटेंट एंड यूज्ड हिज 65B सर्टिफिकेट। ऑनरेबल हाई कोर्ट स्ट्रांगली ऑब्जेक्टेड। हु कंटेंट, व्हाट इज द सोर्स, किस से इसको रिकॉर्ड किया गया था, वो डिवाइस कौन सा है, खाली यूट्यूब से डाउनलोड करके 65B। अब मैं अगेन उस पॉइंट को चैलेंज कर रहा हूं, एडमिसिबिलिटी। एडमिसिबिलिटी तो हो गई, उसने कहां से डाउनलोड किया? यूट्यूब से, 65B दे दिया, एडमिसिबिलिटी हो गई। चैलेंज क्या हो गया? ऑथेंटिसिटी। ऑनरेबल कोर्ट ने, हाई कोर्ट ने स्ट्रांगली पूछ लिया किसने इसको रिकॉर्ड किया, कौन सा डिवाइस था, एंड व्हाट अबाउट द ऑथेंटिसिटी ऑफ दिस रिकॉर्ड। ये एक बड़ा इंपॉर्टेंट हमें सोचना पड़ेगा कि हमें उसकी ऑथेंटिसिटी को जहां ध्यान रखना है। अगर सेकेंडरी एविडेंस भी है, सपोज इन्वेस्टिगेटिंग ऑफिसर ने कोई फाइल में सेकेंडरी एविडेंस डाल दिया, तो हमें ये देखना पड़ेगा एग्जैक्टली प्राइमरी प्रिजर्व है या नहीं है, फॉरेंसिक एनालिसिस हुआ ही नहीं हुआ। राइट सर, 5 मोर, ठीक है। ये एक बड़ा इंपॉर्टेंट एस्पेक्ट रहा है ऐसे केसेस में। लास्टली ईमेल्स को बड़ा इशू है, ईमेल्स को प्रूव करना। ईमेल्स को प्रूव करना भी आसान इसलिए है बिकॉज सपोज सर ने मुझे ईमेल किया है, सो आई विल ओपन माय ईमेल आईडी, आई विल टेक फर्स्ट स्क्रीनशॉट लूंगा मैं। अच्छा, स्क्रीनशॉट लेने के बाद आई हैव टू टेक द मेटाडाटा फर्स्ट। सो मेटाडाटा व्हेन द फाइल वाज क्रिएटेड, modified or accessed, that's a very important part. Metadata has to be captured first, then I will take the hash value, I will take it print out और मैं एक sterile pen drive, what is a sterile pen drive? वो pen drive ऐसा या memory card ऐसा जिसको कभी यूज नहीं किया गया, यही इनको सीसीटीवी में लेना है, यही कहीं से सेकेंडरी एविडेंस ले रहे हैं, तो they have to use the sterile pen drive. sterile क्या होता है? और प्रैक्टिकली सर फॉरगिव मी, क्या करते हैं कि पेन ड्राइव निकालते हैं और कहते हैं इसको डिलीट कर दो, उसमें सब कुछ और इसमें रिकॉर्ड कर लो। सॉरी सर, आपका सारा हैश वैल्यू चेंज है। ये सर्विस जो सब जानते हैं, क्योंकि सर कौन देगा पैसे, इतने पैसे आते नहीं, इतना पेन ड्राइव कहां से लेंगे। नो सॉरी, डिफेंस के लिए आप अच्छा केस बना रहे हैं, डिफेंस के लिए केस बन गया, अगर चलता हुआ पेन ड्राइव में रिकॉर्ड कर लिया, डिलीट कर दिया, डिलीट कुछ नहीं होता, उसमें डाटा रिमेनेंट रहता है, हैश वैल्यू विल डेफिनेटली चेंज। सो दे हैव टू यूज द स्टेराइल पेन ड्राइव, स्टेराइल। तो अब मैं उसकी कॉपी ले लूंगा, 634 से पार्ट ए कौन दूंगा? मैं दूंगा। और जो सर ने, जो 384 पुलिस ऑफिसर राजस्थान पुलिस ने ट्रेन किए हैं सेक्शन 329 सीआरपीसी बीएनएसएस में, वो दे विल टेक, वो आइडेंटिफाई करेंगे हाँ इनके इनबॉक्स में ये है, बट ये प्रिजर्वेशन नोटिस भी दें कि टिल द लॉजिकल कंक्लूजन ऑफ द केस यू हैव टू प्रिजर्व द प्राइमरी एविडेंस इन योर इनबॉक्स। ये अगर करना स्टार्ट कर दें, मैं कह रहा हूं प्रोसिक्यूशन का केस हमेशा स्ट्रांग रहेगा। फर्स्ट लास्ट इंपॉर्टेंट पार्ट है, प्राइमरी सीज करिए, एफएसएल भेजिए, सेकेंडरी सील कर रहे हैं, एसओपी फॉलो करिए, पार्ट ए पार्ट भी लीजिए, प्राइमरी प्रिजर्वेशन का नोटिस दीजिए, इसका फॉरेंसिक एनालिसिस करा दीजिए, बिकॉज आपने प्री एक्विजिशन और पोस्ट एक्विजिशन हैश वैल्यू को मैच किया। और लास्ट इंपॉर्टेंट पार्ट है, अवॉइड MD5 एंड SHA-1 हैश वैल्यू, encourage 252 और 512 हैश वैल्यू। आपको पता है क्यों मैं बोल रहा हूं सर, टेक्निकल वाले जानते हैं, हमेशा 256 या 512 हैश वैल्यू ही आनी चाहिए। MD5 और जो SHA-1 है उसको हमें डिस्करेज करना चाहिए। थैंक यू, जय हिंद सर।
Thank you very much, sir.
Acha, before we formally wind up with the last word from my esteemed brother, Justice Varale, the whole, I think since yesterday we have been congregating here to discuss this cyber safety. I just wanted to say just one aspect, and I'll hand over the mic to brother. Cyber safety, we all said charity begins at home. Now, the safety also begins at home. आप लोग हैं सब, बहुत लोग हैं बहुत who have built their own homes, bungalows बनाए होंगे. तो आप क्या करते हैं पहले? एक तो you raise a wall, 6 feet, 10 feet, 12 feet. उसके ऊपर spike भी लगाते हैं wall पे, so that no intruder comes. Not only that, you CCTV लगाते हैं कि बाहर कौन है, कार है. Then you have a iron gate. घर के अंदर भी your door, wooden door is, in front of it you have an iron grill also. And door में भी क्या करते हैं आप pinhole लगाते हैं. So that you know who is coming, who any, see under 5 is, suspect, suspicious, person who can cause harm. तो इतने सारे आप लोग, we take so much of care of our homes. Unfortunately, what has happened, many of the cyber crimes have happened because of this mobile phone. Mobile phone सबके पास है today. Even हमको क्या, even rickshaw puller has a mobile phone. Just, manual labor also has a mobile phone. Villagers, everybody has a mobile phone. And this mobile phone is an alter ego of the person. As I mentioned in the beginning, we are no more the physical form. All our characters are being transformed into digital form. आप मोबाइल फ़ोन में ऑल आपके सारे फ्रेंड्स के कॉन्टैक्ट्स हैं, आपके मोबाइल में ऐप्स है बैंक्स का कि ये SBI का है, ये HDF का है, आप वहाँ से ट्रांजेक्ट कीजिए, एवरीथिंग इज देयर, ऑल योर डिटेल्स मोबाइल फ़ोन में आपके, एंड आपके गूगल्स करते हैं, एंड यू वॉच सो मेनी थिंग्स, हिस्ट्री, पॉलिटिक्स, व्हाटएवर, आप सर्च करते रहते हैं. And all, when you read all this, there are said cookies, they keep on saying, this wala cookies, we accept. Then therefore, mobile phone is nothing but you in today's world. That is why some countries like UK, USA, Canada, Israel, China, they ask, hey, we want to see your mobile when we allow you to enter. Because they want to see what kind of person you are. Because the mobile phone does not contain only the details about your all intimate or confidential materials, but it also shows your character, your habits, your contact, how you have been living. So the entire personality, whom we have never thought of ourselves, is all contained in his mobile phone. But at the same time, we don't take appropriate care of this mobile phone. So कोई आता है कि we will give you 20% interest on this and so, we happily accept OTP. We let our guards down. The whole entire, you have surrendered. So I just wanted to say that safety begins at home. तो हमारा safety जो है mobile phone, please take care of this mobile phone. It is so important, and we cannot live without this mobile phone today any longer. Inseparable part of our life. So cyber safety, the various aspects of cyber safety have been discussed since yesterday, today also wonderful on various aspects. ऐसे करते हैं. But if you are able to take care of our own mobile phone, which is our identity, your own ourselves, alter ego in the digital form, I think many of the crimes which have been committed can be preventable. With these few words, I just like to hand over to brother.
Thank you, brother. It was really very interesting and an engaging session. We started with the view of Brother Justice Kotiswar Singh, and he opened with an interesting facet, submitting that now in these changing times, the primary and secondary evidence, the line has become so thin that practically it's a blur line. And now we'll have to think on this aspect very carefully. And he was also emphasizing that changing times, as per the changing times, the judicial approach also qua changing times evolved. And the judgments according to the change in the scenario, change in the provisions, the approach also, then there was a change in the approach. Brother Justice Ashok Jain also gave us an insight with his submissions, and firstly I must thank him for a big solace to all of us to be very panic and very hyperactive. Just, you see, be more careful about the other aspect. Financial transaction, money, loss of money, he said, that will be comparing to the entire transaction, which is again controlled by the Reserve Bank, maybe minuscule. But he was right in saying that let us consider the other aspect which is more alarming, like the digital arrest, the deepfake technology, the alteration in your the identity. So this was really something which he gave us another facet of the subject. And he was also emphasizing on the preservation of data. That is, then it took forward this particularly, probably the very important topic was again took forward by Mr. Vikas ji, who also then emphasized on the aspect, and he was very fair. I must appreciate that he was very fair in submitting for all of us that, sir, the cracking of crime in the investigation is not a difficult task for us. But for us, it's the preservation of the evidence and presenting it before that has become a bit aspect to be considered. And he also said that for that we need the expert person, the human resource available with the investigation agency, the prosecution agency, probably now is not so equipped, and they need those persons who are expert in the field, who are professionals, or the other persons who can help, so that with the help of those technically expert persons, professional persons, or the upgrading the human resource available with the agency itself, they can secure the aim of where you can find that the offense is committed, but you are not getting the result, that is the conviction of the offender. And that aspect he emphasized and said that we'll need to look into this aspect, and with the additional human resource, technically advanced or expert, certainly we can achieve that. And then Mr. Dixit also was very candid in saying that, see, we are only focusing on the admissibility, but in that process, we are just forgetting the other important aspect, that is of an authenticity of the evidence. And he suggested, I must appreciate him also, that he said, sir, there are the means and ways. It's not that the investigating agency cannot do it. It can certainly do it, just need is of changing your focus. You change your focus, you look with a different angle to this situation, and then if you can focus the other aspect, that is the authenticity of the evidence, and in that process he also gave some valuable suggestion. And he said that it's not the fault of at times, because it takes time to even understand the law. He said that, and he was right in saying that, see, even after 25 years, there are many issues of the cyber law which are still gray areas. We need to see, we need to train ourselves, we need to update ourselves, we need to get some knowledge, either such from the conferences or the discussions or the interactive sessions, and these are the forum and the opportunities for all of us to update ourselves. Again, Kotiswar was right while he concluded that now mobile is your identity, it is your alter ego. Say in those old days, our poets in the Urdu couplets used to say, "Mera wajud, ye mera wajud, ye meri shairi hai, mera wajud, ye mera कहना hai, mera wajud, ye mera diwan hai." Like that. But now all this is gone. Even if the Gali would have been alive today, his wajud would have been only his mobile, not his diwan. So that's what Brother Kotiswar rightly said, and I really appreciate the inputs provided by all my co-panelists, my brother Kotiswar, Mr. Dixit, Ashok Jain, Vikas ji. I am thankful to them. It also helps